How to avoid probate. Probate is a court-supervised process where you marshal all the assets, creditors get paid, and then whatever is left over goes to the heirs and named beneficiaries. Probate has disadvantages. With proper estate planning, you can avoid it. One major disadvantage to probate is that it can be very expensive. According to Florida law, an attorney can charge up to 3% of the estate. To put this in its context, let's say an estate is worth $500,000. Then the attorney's fees will be $15,000. This also means your intended heirs will get $15,000 less. So why spend more money on attorneys than you have to? Another disadvantage is that probate takes a long time. A formal probate can take anywhere from 9 to 12 months to complete in the state of Florida, and even longer if there are complex issues and litigation involved. Meanwhile, the assets are frozen until the probate is completed. In contrast, by avoiding probate, you can distribute assets quickly and seamlessly. In addition, since probate is handled in court, the probate becomes a matter of public record. This also means your creditors become a matter of public record as well. If your privacy is important to you, then avoiding probate is a must. There is common misconception out there that if you have a will, then your estate will not go through probate. If all you have is a will, I can assure you, your estate will most definitely end up in probate court. A will alone does not prevent probate. To avoid probate in Florida, you do have options. Create a trust. It can be a revocable trust or any other trust, depending on your circumstances and your end goals. Make sure you designate beneficiaries, either contractually, like in a life insurance policy, for example, and on your accounts. That includes bank accounts, stocks, bonds, securities, and any other investment accounts you may have. You can also transfer your assets by deed. In Florida, you can use an enhanced life estate deed, commonly known as a ladybird deed, where you can put your property for life, you can own it for life in the deed, and then the remainder interest can go to a named beneficiary. This is a great tool to avoid probate. You can also own property as joint tenants with rights of survivorship. That means if two people own property together as joint tenants with rights of survivorship, when one owner passes away, the surviving owner automatically gets 100% interest in the property, and it passes by operation of law. With an experienced attorney, you can plan your estate so that your assets pass to your beneficiaries quickly and easily. This is Dina with your legal concept. Hope this helps.